Okay, we're live.
All right, good afternoon and welcome back to the House Environment Committee. As noted before our break, we are going to talk about proposal of amendment on what is it, H 231, which we are in the process of debating on the floor. We have with us Representative Oliver from the Judiciary Committee, who has offered us some perspective on some of the questions we were asked. Welcome.
Hi there, Tom Oliver, House Judiciary. Side note, practicing law enforcement officer as well. This came up at our committee while several individuals, the first point that we noticed, made note of was or other projectile or implement. We didn't know what that meant, and we didn't know if that was language that you had to have in there for any specific reason.
And we also had with us the Fish and Wildlife, many representatives from the Fish and Wildlife Department, including the Colonel. Would you like to comment on, I presume you were part of bringing that language to us? And would you
Yes, ma'am.
comment on the intention there?
Yes, ma'am. So that was simply an oversight on our part. It was never, this law has always applied to long guns and it was supposed to apply to long guns. It was, what we're attempting to do is address the changing technology, and that was an oversight on our part. So it should not include handguns.
Okay. And so if we struck those few additional words there, we would satisfy the concerns of the Judiciary Committee and as also still meet the needs of Fish and Wildlife.
Ma'am, I believe so.
Great.
And the second point that we made note of was when there's a vehicle in the right of way or public highway shall upon demand an enforcement officer exhibit the firearm for examination to determine compliance with this section. I think the concern was the compliance would ultimately result, if they are non-compliant, in a violation, which would be basically a self-incrimination. You follow?
So just so others can follow, we're in section.
We are, yeah, section 4,
A new,
page 494, top of the page. 94.
yeah, but we also have, I'm looking at the bill, but anyway, that's fine. Page 494, if you're in the calendar.
4705.
So, well, subsection 4, Michael, we were noting used to have numbers, and that 4 is existing language. And
Yes,
it's underlined because you broke it out into a new section, or is it?
it probably should not be underlined. I think that was probably a misprint in printing.
Is the vehicle propelled new?
Yep.
So the new language is sub 3?
Yes. And as you just referenced, Chair, the sub for that language has been there for a long, long time. And it says mechanical power to differentiate from the definition of motor vehicle. There's a definition of motor vehicle accepts things like snowmobiles and ATVs. So this was intended to bring in anything by mechanical power. Representative Parsons asked about electric bikes. They are not motor vehicles, but they are propelled by mechanical power.
No hunting from your e-bike. How often does that come up?
Not specifically hunting, but they're very popular for hunting.
They are very
Believe it or not.
Oh, that's true, yeah.
You put the wide tire on them, they can carry a lot of weight, and you can go very silently a lot further than people are willing to walk. So, they're
Yes,
actually
there you
quite
go. You're right. Okay, does that change your perspective on this, Representative Oliver?
It presents a challenge for law enforcement officers, obviously, for public or for their safety, officer safety purposes. But as far as it's kind of to me, a technicality that, they're within their curtilage of their car, they're inside their personal vehicle. It's subject to warrant for any other search. unless exigent circumstances. I don't think exigent circumstances would apply if you could ask the person to get out of it for some reason, but the opinion of many other officers that I've asked about this as well is that you would need a warrant to inspect it, to open it, to see if it is loaded.
Michael?
What if the firearm was visible?
That's what I mean, is if it was visible.
So you couldn't ask them to exhibit it?
I would have to open it just like I would a glove box.
Not necessarily for a crossbow.
No, not if I could see it. I could see that it's unloaded because there would be no bolt in it or the string would be collapsed.
But can't you ask when you just generally, not in the context of this, when you see a visible firearm, ask for it to be presented to you?
I ask them, and if they comply, that's fine. But if they say no, then I respect their wishes.
Madam Chair, if I may,
Yeah.
in Title 10, in 4705, after the section of law, there's a section that refers to the constitutionality, and it's state versus Duranlo, which says that provisions in this section prohibiting the carrying of loaded rifles and shotguns in or on mechanically propelled vehicles on public highways is not such an infringement on the constitutional right, bear arms as to be invalid. If they're going to address it, the issue.
I don't know what, wait, not ours, but yeah. I don't know when that case law came out, and there's been a lot of search and seizure case law since, probably, I'm guessing. It's evolved a lot. Used to be able to search the cabin of a vehicle incident to arrest. The whole vehicle. And then that got brought down to the lungible area, and now it's anything closed or locked. So.
I guess I want to give you a second, but I'm just wondering about, this is a section called shooting from motor vehicles or aircraft shooting from or across highway permit. So does that not make it relevant to someone who has shot from their car?
Yes, it's relevant. Anyone shooting from their car.
Exclusively?
No, not exclusively.
Is it relevant to anyone?
It's relevant to anyone that's within the right of way,
Whether they've shot from their car or not?
whether they've shot from their car or not.
Okay. Representative Sakowitz.
Yeah, I guess I'm a little confused about where the language came from. So we're saying that all this underlying language in section 4 now, this is all existing language. We did not add this to the bill, but this to statutes in the bill, but it's not,
Right.
this is not additional language to statute.
That's correct.
It's in 3. 3 is new.
3 is new. But this is a language which seems to be causing consternation. So we could remove this from our bill and it would not change the changes that we are trying to make. Is that right?
That's correct.
But
So you're making a suggestion.
This
Goal
could
of that's for.
pass constitutional muster.
Yeah.
We don't know if it does or does not, but some lawyers, recent lawyers,
Well, I'm saying
are
that,
concerned with it.
yeah, but I'm saying that we don't need to make that decision here. That we simply can say, this is in our bill basically by accident, and it probably should never have been here to begin with. And so we take it out because it wasn't it doesn't serve a purpose. And striking that section from statute is a much bigger policy conversation, which isn't really appropriate in this particular moment.
right.
And we're not the right committee. That's probably true as well.
But
I would have a hard time not showing that language.
yeah, because he's numbered it.
If you, no, I could redo the whole structuring, but if you want to include that air gun language and then the unless it is on cock language, I might
Can,
be hard
yeah,
to do that.
when we amend this, can we reprint this with that not underlined down?
Yes,
And so it shows that that's the existing statute.
you could do that.
That doesn't make the question go away.
Doesn't make the question go away, but it makes it clear that we're not actually trying to do we're not changing anything with this technical corrections, but
Just so you're aware, judiciary is aware that you weren't trying to change that. We just, it hit some radars on people. That's all it did.
yeah, no, I understand.
And maybe it's something that I hate to take away any tools that Fish and Wildlife, make it more difficult for them. Getting warrants is more time consuming and difficult.
What if it says show up on request? The enforcement officer
Where are we, Michael?
be on page 494 of the calendar.
494.
Page six. Gave my calendar away. Page 6 on the bill. Thank you.
On request of an enforcement officer,
You would,
with their consent, exhibit the file.
So we're making a policy change.
Yeah, that's a,
To
I'm not
that
sure I
section.
wanna go there here today.
Representative Bartholomew.
I guess I'm really confused why we're concerned with this, because if it hasn't been, if the constitutionality hasn't been tested and it's existing law, then a law enforcement officer can demand to inspect. That's what the law says. We're not changing anything. So why are we even talking about this? It's
think
the
the
other
underlying-
section.
Just that the underline drew attention
Well,
to it and then people have realized it's.
We're not the right committee to change that language anyway, and it's existing law, and it hasn't been ruled unconstitutional by any court.
Yes, we're just trying to find our way out of this particular moment.
So I would say let's focus on number 3 and forget number 4 because it's irrelevant to this committee and to the bill.
So just
But
take the underline.
doesn't
pull it
that-
out.
That still creates a problem when it goes back to the floor for this language, because we all know it exists already and it's been brought up by people outside of this committee and questioned.
Yeah, but I mean, we question statute every day, and when the way that we, the way we address that as legislators is to introduce a bill that actually then makes debate about it happen so that it gets its due process. This hasn't had any due process. So someone could still introduce a change, and then the body would have to vote on whether or not they want to make that change without any review of the language. Representative Bartham.
It might not be, and anyone had tried to amend that section, it probably would not be germane because it would unduly expand the scope of the bill.
Sure would. At any rate, are you satisfied? You've delivered your message.
I can deliver the response back. But it's not gonna, change it.
Thank you.
What, can,
Oh, go ahead, Representative Moore.
reference B1. We talked about a rifle, air gun, shotgun, or other projectile implement, and I believe I asked the question previously about other types of weapon. I think I didn't mean it humorously, but I was just thinking in my mind that if somebody had a paintball gun that was laying on the seat, it's not used for hunting, and it's not used for necessarily killing. But I did ask the question. I think the colonel said that it also doesn't it doesn't pertain to that. Also does not pertain to the Daisy Rider BB gun. If those are not.
That's the language we're going to strike.
We're striking
Or
or other projectile implement.
projectile, yes, that's going to be our amendment.
But you're gonna leave here, then?
That's still red.
Yeah, because Michael?
I was just gonna say, I think you need to see a visual of what an air gun is, to see what the department is trying to get at. Because they're trying to stay one step ahead of the evolution of these weapons, because they're very apt to be used by people taking wildlife illegally.
You would have to be able to have some sort of lethal means. Where the paintball gun would not.
No, yeah, that was my point, but would it count as a search?
Yes,
Demand to see it and.
Yeah. So
but we're adding air guns still.
Yes.
And we understand the department was looking at this from what you're, I think, addressing, which is this is an evolving technology. It would be very helpful to stay ahead of it, but we've stumbled on something. And so we're going to put that aside for now and just add air gun. Okay,
and strike other projectile.
yes. Representative Nor.
Chair, could I ask that we provide a legal definition of air gun? Would that help?
Do we have one, Michael? Would help. It might make it more strict. Representative Pritchard.
The easy way to do this may be just say 1.77 caliber or, I mean, that,
It's not a caliber.
Possible.
Well, they actually have.
the air gun's not
Caliber.
specified as a caliber. It doesn't have a caliber. I think they all have
There are some
calibers.
now that will kill deer.
Oh, they, 200 yards.
Yeah.
And they use CO2 typically.
And some do shoot projectiles with the caliber and some shoot large crossbow bolts.
And they don't have a caliber designation.
Yeah, some do.
Okay. I was trying to think of a way as far as the Red Ryder BB gun goes, if it's 177 caliber or.
Is there a definition of air gun that is either in statute or rule? Not,
Try to find one.
and I guess what's your thinking on that?
Why did I ask for that? Just to avoid the confusion around the term air gun. Does it include Daisy BB gun? Does it include a pellet gun? Or what does it include? It's an air gun. What does it mean?
I think you'll find a standard of diameter and velocity in other states.
It's included in here, so we know what we're talking about.
Is it the same definition?
Yeah.
Maybe I suggest that this is gonna go to the Senate and we strike air gun right for now and then suggest that people work on a good definition and.
Yeah, it's a good suggestion.
So strike the entire section.
That solves a lot of trouble. Are those a lot of changes in there?
And that doesn't give the Fish and Wildlife any means of. I mean, if this is a real problem,
Gender conforming is the only other change I'm seeing in that section 4.
you couldn't just put excludes one air rifles of 1.80 caliber or less. Caliber is determined by bore. So regardless if it has a caliber designation or not, it's still, I mean, it's got a bore size, so it can, I mean, it's gonna have a caliber designation. And if you do the 170, 180, say, or whatever, and less, then it excludes pump up pellet guns and Red Ryder BB guns and all the, you know, all that stuff. They'll be excluded and still protect what you're trying to do.
I think that Representative Sakowitz had a proposal, which
There's currently 22 states with air gun hunting laws. Just Googling it and they all have caliber standards,
Yeah.
etc.
What state do you say?
I just Googled what states allow.
Are the calibers all the same across the state? So they're all different calibers?
I'm feeling a strong pull towards Representative Sakowitz's suggestion that if Fish and Wildlife, you know, wants to help flesh this out, then we take it out of our bill for now because it requires more discussion. And we advise you to maybe bring it to the other body if it's still important to you. Does that work does anyone on our committee object to that path forward?
I don't, if Fish and Wildlife isn't okay with it.
Basically, we're gonna pull section 4 from our bill. And
Section 4.
if others want to, then we pass it, it goes to the Senate and they can noodle on this if they so choose, or if someone else wants to take this topic up in a larger conversation in the future, they may.
Procedural question.
Yeah.
Thank you, Madam Chair. So we take it out, it goes to the Senate, they put it in. Does it come back to us for concurrence or not?
Sure.
So it would end up on the floor anyway.
Yeah, but they will have noodled on it and had time to consider.
So my opinion would be not to walk away from it, just put it in there and it kind of forces them to noodle on it. But Just
We may never get off the.
I lost
floor.
on another bill. I suggested. Yeah, maybe they don't noodle.
I think that what we've discovered is this is a little bit beyond a technical correction. Yeah, it's opening a policy change conversation that hasn't happened yet. So anyway, thank you for
Thank you.
bringing this to us and
You representative.
joining us this afternoon.
It was a pleasure to see you.
Michael. So, well, when you join us, we'll follow up on what we're gonna, how this gets presented. This is removing a section. It's kind of an interesting amendment,
Yeah.
moving a lot from our bill. So how will this look as an amendment?
It will say
So you
strike
just-
section,
Section 4. Okay,
section 4 in its entirety and insert in lieu thereof, it'll be a bracket and then it'll say deleted within the bracket and then a closed bracket.
great. Be short. And do we vote on that now?
Can if you would like.
Sure. Is there a motion to strike section 4 from our bill?
Motion.
Representative Tagliavia moves we strike section 4 from our bill. Seconded. Is thirded. We're out to vote, team.
Is it just do I need to
That's
have
what I'm
a,
wondering. Do is this an official amendment that we need to do?
So you don't have possession of it anymore, correct? So it's really you're taking a straw vote.
Okay.
Or you are going to agree that everybody's name is going to be on it, or a combination of people's names are going to be on it.
Probably I don't know. What's easiest?
It's easy either way.
Okay.
Actually, the report.
Does everyone want their name on this amendment? The names will be longer than the amendment, but we'll show unified
It'll show up.
Usually,
representative.
seems like when I've seen it, it's usually the reporter of the bill who puts it in as the amendment.
Yeah, we've done
Or
it
the
this way.
You do it either way.
Yeah. Well, I think folks were, well, yeah, doesn't matter.
I mean, if people are amenable to having their names on the amendment, I think that's a nice clear signal to the body.
Yeah, it is. Does anyone object to having their name on the amendment? Representative Chapin, are you with us?
Yes.
Okay, so do you object to having your name on the amendment?
No, I do not.
Okay, great. So I think everyone wants their name on the amendment. And we'll just,
Okay.
and we don't have to vote on it because we're all supporting it. Great. All right, moving on. We are here actually to walk through and we'll hear from Representative Witz and walk through H230. Do you want to just give it your thoughts on where we're sitting?
Sure. So H320 is a bill that was been 230, gosh, I have it here wrong in my notes. H230 is a bill that's been requested by the Fish and Wildlife Department. Most of it is a repeat of a very similar bill from last year. It has sections that concern fishing and fishing tournaments, big game and other violations, the protection of reptiles and amphibians, public notice of taking permits for threatened and endangered species. There's a section on the confidential nature of the habitat of certain threatened and endangered species, and a section that repeals language that reimburses farmers whose crops are damaged by black bear. And then there's section 8, which was not in last year's bill, which has language which was adapted from a threatened and endangered species bill that I introduced last year that had support of the entire Environment and Energy Committee, but we did not take it up. And so that language is in here. It's a small part of this bill. But it is in there and makes a difference. And so it's a bill that really overall contains some nice additional protections for the biodiversity of the state and has some small changes to the hunting and fishing statutes.
Representative Bartholomew,
What happened to the bill last year? Can you remind me?
you didn't take it up. We just didn't get to it. leaving and I just want to, I have their notes and we can talk about it. I think it looks great overall. I had a couple in the back.
Okay.
And. Right, thank you. We can go ahead.
This is Mike O'Grady with Legislative Council to walk through H230 for you. Section 1 is an amendment to the ability of the department to issue licenses for fishing. Page 2, lines 16 through 19 provides that the commissioner may designate Labor Day weekend each year as pre-mentored fishing weekend, during which one unlicensed angler can fish with one licensed angler throughout the 3-day period. Should I move on? Section 2 is relating to fishing tournaments. First, it clarifies that tournaments on the Connecticut are not subject to a permit requirement because they are not actually in Vermont unless they are on the Moore and Comerford reservoirs. And then at the bottom of, or actually midway through the page, a contest may run multiple days, but they had to be consecutive for that contest to be considered a single event. And then at the bottom of the page, the fee for the tournament's permit is changing from a general fee of $50 to one based on number of participants. Tournaments with up to 25 participants pay a fee of $10. Tournaments with 26 to 50 pay a fee of $30. And tournaments with more than 50 participants pay a fee of $100.
Representative Tagliavia.
I'm concerned with the reasoning behind all of a sudden requiring a permit for a tournament.
It's not all of a sudden, it's been on the books for many years.
Just trying to find ways not to discourage these kind of things, recreational activities on the water. Is this going to wind up generating that much more revenue?
I don't recall how many tournaments there are per year. There are not that many, but it does take agency department staff time to review the applications and effectively administer and police the tournament. So there is cost involved to the department.
Thank you.
Page 4, section 3, this is amending the violations for big game violation first. What is being done is moving the actual activity that is a big game violation into its own definition at the bottom of page 4. So a big game violation means violations relating to taking, possessing, transporting, buying, or selling big game, violations of Chapter 123, and the rules related to threatened and endangered species, violations of the title relating to hunting, fishing, and trapping while under suspension, violation relating to the trade in covered animal parts, interference with hunting, fishing, or trapping, and then illegal commercial importation or possession of wild animals in violation of the title.
Yeah, hold on one second.
Excuse me?
I think Representative Austin has a question and I need to go a little slower.
Yeah.
Representative Austin.
Just what is the definition of big game?
I thought I had brought the definitions with me, but I must have left them. It's deer, moose,
Turkey.
turkey,
Turkey.
Anadromous Connecticut salmon, and what am I missing?
Bear?
Bear.
Interesting. Thank you.
And then this section amends the penalty amounts for big game violations, increasing the maximum for an initial violation from 1,000 to 2,000 and the minimum from 400 to 500. And then for a second or subsequent, increasing from 4,000 to 5,000 and increasing the potential imprisonment time from 60 to 180 days. We're going from there. Page 5, line 9, section 4. This is to provide that, well, it's an interesting proposal because it might change. This generally, fish and wildlife violations are criminal, except for those that are listed in the next section, section 5, the minor fish and wildlife violations, which are civil, and there's only, I think, 7 or 8 of them right now. But there's an issue that I would say the state has, and that many fish and wildlife violations aren't pursued by state's attorneys or attorney generals because of workload or other issues. And so you're going to talk in a minute about having. Actually, could I just skip the section until we get to a later section? I think I need to have that conversation first.
Okay, sure.
And then come back to this one. So section 5 is the minor fish and wildlife violations. And one of the things that it does is it provides that except for big game offenses and under revocation offenses, a warden may determine that a fish and wildlife violation not listed in the section should be charged as a minor violation based on certain factors. So what that does is it gives the warden the discretion to determine if a violation is going to be criminal or civil. And that's a significant amount of enforcement discretion, even with the factors that are listed, which are limiting and do help limit or direct how the warden would act. But you have an issue with what's called the common benefits clause. Same people go out on the same day, different wardens. One says that's criminal and one says that's civil. And so one person now has a criminal violation on their record and one does not. And it creates a dual enforcement track as well, which is problematic because you might have effectively one in the criminal division that's not getting prosecuted because of the workload issues, and one in the civil, in the judicial bureau that gets addressed right away. And so that creates a common benefits issue as well. But I talked to the department about the department, I think, made a pretty reasonable proposal to address that. And I don't know if you want me to say what the proposal is or if you want the department to say what the proposal is.
It would be good to hear directly from the department, which we will be doing, but if you think it's part of our understanding of the previous section,
It is.
so we should hear from the department now, if that's possible. You can.
Okay. For the record, my name is Hannah Smith. I'm the general counsel with the Department of Fish and Wildlife. And we, the common benefits clause issue that Michael identified is very relevant to the wardens who are charged with enforcing these issues. And what the proposal was really intended to do was to make the majority of these violations civil. And so we, based on the feedback we got from Legislative Council, we proposed that this language that begins on line 12 of page 6, I can read it out loud. So except for big game offenses and under revocation offenses.
Well, Michael just read it.
No, this is new.
This is what we would propose.
Oh, I'm sorry.
Yeah.
Yes.
Any fish and wildlife violation as defined by 10 VSA 4551, not otherwise listed in this section, shall be charged as a minor violation, provided that the offender has no prior history of fish and wildlife violations. B, there's no need to seize evidence in order to further investigate the violation. D, there is no need for a criminal warrant to further investigate the violation. And G, there's no possibility of forfeiture. So civil violation would be the default for those violations that did not have associated jail time and did not otherwise meet the conditions outlined under provisions A through D.
And forfeiture is forfeiture of your license?
No, it's forfeiture of the equipment that was used in the violation, which can include motor vehicles.
E-bikes.
Boats. Boats. Oh, sure.
Thanks, and elephants.
That's proposed language though?
Yeah, proposed.
So you haven't.
That's not here right now.
That's not in front of you. It's not in front of you now. So it takes away the whole dual enforcement issue. It just said everything civil unless these criteria happen, and then it's going to be criminal. And you do that for other types of violations out there. You know, one of my favorites is if you're going to set off explosives and you do it one time, it's without a license, it's a civil offense. But if you do it 2 times, it's a criminal offense. So, you know, you can make those kinds of distinctions. It's not giving discretion to the wardens to try to make a field decision. It's basically saying it's civil unless they determine that one of those criteria occur, and then it's criminal.
So I just see if I'm understanding the bigger picture where you're headed with this, which is I think that we're increasing the number of violations that are more points, whatever the the 20 points instead of the 10 points. What is the word for that? But the categories of penalty. So anyway, but at the same time saying they don't need to be criminal, but we're going to increase the fines and the points. Kind of, is that what is happening? And even in the previous bill that we were just talking about?
So remember, there's 2 ways you get penalized for a fish and wildlife violation. You get the points. General default is 5 unless it's specifically listed as 10 or 20. And then depending on how many points you accrue, you might lose your license. But at the same time, you get assessed a fine and potentially jail time, depending on the type of violation it is. And so what the department, I think, is proposing is you keep the uniform point system because you want that as a deterrent for people. You want the deterrent of no license to be out there, while also saying most of the violations are civil and are just going to have a fine instead of subjecting people to potential imprisonment.
Right. And I'm just saying we're kind of raising the bar, but sort of lowering the criminal, like we're doing civil instead of criminal. So we're saying the penalties might be higher, but like it's civil instead of criminal.
So if you do what the department wants, you have to change that section that came before because it says generally everything's in the criminal division. You have to change the default penalty because the default penalty is $1,000 plus imprisonment. And so there's a couple of things that you would have to change.
Well, some of the violations would still be criminal.
Right.
So we wouldn't change the default penalty. The Judicial Bureau, which sets the
Oh,
fines,
that's a fair point.
would establish the penalties and
Right.
waiver penalties for the civil.
That's a
yes.
fair point. So you're gonna have to have Judge Zone come in and talk to you about that would be done. Probably need to have him in anyway, because what is it? This section also places potential, if you do nothing different from what's in the bill, you're putting more offenses in the Judicial Bureau anyway. So you have to confer with them like you did in the previous bill.
Okay.
Yeah, excuse me, just to your question though, the big game issue and this are separate in the sense that roughly 80% of Fish and Wildlife violations are written on a criminal information. They are not big game offenses, and they do not fall into this section of big game that was talked about beforehand. Those 80% of violations can be taking fish that are the wrong size, taking too many fish, fishing with too many lines. There's a whole variety of things that fit into that. And those currently are issued as a criminal ticket, but they're unique in that you can pay them through the mail. And so one of the concerns is that people just pay them and don't realize that they then have a criminal record. And so what we're trying to do is people who are not intentionally violating the law or who have a habit of violating the law, we're able to address it civilly and not make them criminals. They probably don't always understand. I mean, there's explanation, there's paper, there's all kinds of stuff that wants to talk about it, but it's oftentimes lost in translation. And so the big game thing is a little bit separate. And I just wanted to make that point that you are raising big game, but this part doesn't necessarily specifically tie to that.
Thank you.
That makes sense.
Yeah, that's what I was asking. Thank you.
Okay, should I move on? Here on page 793, section 6. This is a new section of law that gives the commissioner the ability to adopt rules related to protection, conservation, and taking of reptiles and amphibians. This is a commissioner's rule. It is not a Fish and Wildlife Board rule. But the rule may prohibit the possession and importation of species that pose a threat to species and ecosystems in Vermont, and allow the department to establish a list of prohibited or restricted species. Allows for waivers for possession of prohibited species legally acquired as a pet prior to July 1, 2025. It prohibits the taking and collection of specified reptiles and amphibians. It establishes an open season for common species, so there would be effectively allowed taking. It would establish daily, season, and possession limits, bag limits. It would establish territorial limits, management units. It was prescribed the manner and means of taking any species or variety, including reporting and tagging. Establish restrictions on taking based on sex, maturity, or other physical distinction. Page 8, it would designate wildlife management units for various species or varieties. So it's effectively giving the authority to the commissioner to adopt a rule for management, taking, and seasons of taking. Move on.
Representative Austin.
Yeah, I don't understand like open season for common species for taking, what does that mean? I mean, you could just take a ton of turtles or frogs or something.
Right now, yes, ma'am.
But doesn't that say they're allowed to do that?
They are right now. This would allow us.
Oh, I see, okay. Oh, okay.
Seasons,
I'm in.
limits.
I'll take 1,000 snapping turtles right now,
Gotcha.
and there's no issue with that.
Great, thank you for getting more.
So it might be helpful, we didn't do this at the very beginning, but if you don't mind, just section by section explaining, the why for the request or the thought behind it.
Madam Chair, thank you. This is a department request.
Yes.
So, for the record, I'm Rosalind Renfrew, Wildlife Diversity Program Manager at Fish and Wildlife. And what prompted this bill, or this part of the bill, what is behind it at the moment is the problem with a particular species that threatens turtles, and it's called the red-eared pond slider. And it is a species that is native to other parts, southern parts of the country. In Mexico, has been self-introducing itself, and maybe with human assistance, with a lot of human assistance actually, to the rest of the US, and has caused a lot of problems in other states. And Vermont's one of the few states that hasn't yet seen them develop, viable breeding populations, because we're just a little far north. But they have started showing up in a couple places here, and they've wreaked havoc on our native species. that exist further south of us, and there's big concern about them taking over the niche space of our native species and also spreading disease. And this is a problem because it's the most common pet turtle that you can get at any pet store or over online. And it's very popular. So it's a lot of people have them as pets. I'm sure there's a lot of Vermonters who have them as pets. And people get tired of having them, or their child grows up and they release them. And so there's always a hazard with that. And so our herpetologist, Luke Groff, has been trying to track down any potential sightings of these and immediately go try to catch them. They're very difficult to find and catch. They're down in the water. So really the ultimate solution is to just prevent the problem in the first place and try to dissuade people from having them as pets and not allowing that to happen and have them choose other species. So this deals with that, and it also has a legacy clause so that people who already have one aren't going to, if and when this goes into effect, aren't going to think they're in violation and release them. It's like a legacy clause.
Thank you.
Mhm.
Representative Britton.
How do they, what damage do they do? What?
Yeah, so when you release, when you release them in the wild, they can harbor disease and then spread it to the local population.
And affected that
And
way.
they reproduce really rapidly compared to some of our other turtles here. And they end up sort of taking over the habitat and excluding the species that we're trying to conserve.
Red-eared turtle.
Yeah, red-eared slider, red-eared or pond slider. It's a type of pond slider.
Moving on.
Page 8, section 7, you're in that section of law related to importation, possession, and stocking of wild animals. This is to clarify, a person shall not bring in to transport, possess in the state live wild birds or animals of any kind, including reptiles, amphibians, or feral swine without authorization from the commissioner. Importation permits may be granted under rules, requirements, or conditions that the commissioner prescribes. On page 9, line 8 through the bottom of the page, this is some of the provisions that would be adopted to prevent a person from importation, possession, etc. Person shall not take, collect, possess, sell, import, or export any wild bird or animal or parts thereof, dead or alive, for commercial purposes unless authorized by the board, rules of the commissioner, or a permit from the commissioner. Person shall not take, collect, or possess any reptile or amphibian, parts thereof, for personal use unless authorized by rules of the commissioner or a permanent person who violates this section may be subject to the penalties set forth in 4518, and also may be required to pay additional penalties based on reasonable mitigation and economic benefit associated. The commissioner may bring an action in the criminal division, having jurisdiction where the offense is stated to have occurred, or the environmental division of the Superior Court to compel reasonable mitigation, recover economic benefits. And that's really that section. Page 10, line 12, section 8, this is the endangered species incidental take. Except as authorized, a person shall not take, possess, or transport wildlife or wild plants that are members of a threatened or endangered species, or sell or offer for sale in intrastate commerce. They're already banned in interstate because that's usually covered by the Federal Endangered Species Act. This is intrastate. And they shall not deliver, receive, carry, transport, or ship a threatened or endangered species in intrastate commerce. And they cannot import a threatened or endangered species into or export a threatened or endangered species from Vermont. Page 11, line 3, section 9, this is
If you have time, I'd like to just hear the why for that part of it.
It provides, I think Representative Sacklowitz might have added this in this bill last year, but it provides added protection for movement of species within the state so that, for example, the spread of disease I was talking about earlier, if animals are moved around and people are possessing them or they're picking them up off the road and have them in their car and they're taking them somewhere, they need authority to be able to do that, so that you're not spreading disease or you're not changing the genetic makeup of a local population by moving it from one place to another. So it's generally good practice to understand who is able to transport wildlife in places by permit rather than have it going on without knowledge of how much it's happening or which species it's happening to. What's that prohibited?
Just sort of clarifying, it seems like all those things are already illegal, right?
Honestly, I don't think the sale or offer for sale in interstate commerce is really specifically set forth in the threatened and endangered species chapter. There's the prohibition on taking or transport.
So I was thinking how you couldn't sell it if you can't take, possess, or transport it, how could you sell it?
I mean, I understand your point, but there is no specific prohibition on sale.
Yeah, so it's kind of.
Should I go forward? I want to take you to section 10 before you look at section 9. And that's because the changes in section 10 really inform the changes in section 9. So this is the authority of the agent, the department commissioner, to withhold information regarding the location of threatened or endangered species or habitats, except to the owner of the land in which they're located, a potential buyer, qualified individuals or organizations doing scientific research, or during regulatory processes, with the exception of the threatened or endangered species listed, so like Act 215. So the secretary shall maintain a subset list of threatened and endangered species whose specific names shall not be included in regulatory planning. Subset shall include the species for which the names and locations shall not be disclosed because of the risk that the species will be significantly harmed by an unauthorized take. And the list shall be based on the rarity of the species, collection and commercial trade activities in Vermont and other state countries. And so that's just enhancing the authority that the secretary has to maintain the confidentiality of threatened and endangered species and where they are located.
Yeah, and this would apply to only a handful of species that are particularly vulnerable if their locations are known. In general, we like to be open with our data and share our data and let people be aware of what's around them. That's a good thing. So this is for, right now we have a draft list of 8 species total, plants and animals, that would be on that list because they're so vulnerable to collection if the locations are known. And this has been a known problem. There's stories from other states. We don't have, well, I don't know if we have a story like that in Vermont, but.
Wasn't there an issue with the rattlesnakes in Rutland for a while? People were trying to find them.
Yeah.
So let me see if I understand though. I think, so you're saying you wouldn't even share the species name?
Right, because there's been cases where people are taking public documents such as, an Act 250 process. There's a lot of documents that are available to the public, and they can put 2 and 2 together if they know where that project location is and they know what species was found there. And I guess this has happened in other states. I'm not familiar with the details.
I think I need to reread that, but I got it. Thank you. Representative Austin.
Yep. So how does someone who buys land and wants to build a house know if these species exists on that land.
So there is a pullout for that scenario, for a few scenarios, and that's one of them is that the person who owns the land is informed of this information. They can have this information.
And would that limit their location of where they wanted to build? Like,
Oh, that's a whole different issue.
That
My
is?
hope would be no.
okay,
You can usually work those things out.
Going back to where the changes at the top of line, page 14. It does say shall inform the owner, and that's being struck. Secretary shall disclose the information. And then it's,
Except to,
but it's not saying they shall do it anymore. It's just saying,
fair point.
man, just notice that.
So can I go backwards a section?
Hmm.
So in section 9, this is the threatened and endangered species. This is the incidental taking permit when the commissioner or secretary can authorize the taking of a threatened or endangered species. This is just to basically incorporate into this section that concept that except for threatened and endangered species listed by the secretary in accordance with 5410B, those that are going to be listed
You're on.
page 12, line 13 and 14. Those species that are going to be listed as confidential, then there's going to be to issue a permit, the secretary has to provide public notice, not fewer than 30 days. So this is just taking out a public notice out of the posting of permits and the applications, those species that are listed as confidential.
I want to go back to the shall tell the landowner part of that. Was that intentional that it's no longer a shall?
Where are you? Page 14, line 7 through 9.
Does anyone know where that came from, or can anyone speak to that? We can,
Is the question is why we are striking the end of 7 and line 8?
well, it says, the way it reads as it's in statute today, it actually says you shall tell the landowner. And now it's sort of just saying you may, kind of, there's not a may or shall, but it doesn't require that the landowner is told.
I'm not sure what context the secretary or the department was reaching out directly to landowners other than in regulatory proceedings like Act 250, which is really the issue we're trying to address here. The way that it's written now, essentially, the secretary can disclose this information to a landowner or a potential buyer to qualified organizations. I'm not sure when we ever would have been. We're not tracking home sales and informing people every time there's a real estate transaction about whether or not there's an endangered species on their property. It's really in the context of development projects where that comes up. And so currently the secretary is already maintaining the confidentiality of this information, except under certain circumstances where, for example, in Act 250 proceedings, we provide information, or primarily private landowners or developers, consultants are providing information to that body about the property itself. And so what this language does specifically is allow the department to develop a list of species that remain confidential even in those regulatory proceedings. So it's just an added layer of protection on top of the department's existing ability to maintain the confidentiality of those species locations.
Representative Austin.
yeah. I don't understand, because then the landowner, in not knowing that information, could destroy that habitat, right? Inadvertently.
Well, I think that, I mean, it it is true that a landowner may inadvertently destroy habitat. I mean, that's something that we just don't have the capacity to be out regulating on every property ever. Our focus is typically on projects where large scale development that's subject either to 250 or 248 are taking place. Whenever we discover a violation, we have enforcement authority, but our ability to actually ensure that there's never any impact to some of these species it's just limited by staff capacity.
Right, but they wouldn't know they had committed a violation, right?
That's true. It happens. And again, a lot of the information, the vast majority of information about TNE species is available on our website. It is available in the Natural Heritage Database. So landowners, responsible landowners are able to locate a lot of that information. This is just referring to a specific subset of species where we're actually trying to maintain confidentiality around their location.
Would you still have the same, I mean, a lot of the rare threatened endangered species, in fact, maybe all of it is sort of anonymous. It doesn't, they're not linked to specific species. They're kind of big blobs on a map saying, heads up, there's something here, but we're not going to say what it is.
Some, well, go ahead, Rex.
So, I mean, so in Act 250 process, for example, that information would become available to anyone who's looking to develop, put in a development.
Yeah, no, I understand that. I was thinking more about Representative Austin's question about a landowner finding out more information about the property. It's already anonymous is my point. It's like a lot of this information. So I guess I'm wondering why you need to make it this subset. Like as a member of the general public, at least last I checked, you go and you look for rare threatened endangered species. It doesn't necessarily say the species. In fact, I think it doesn't say the species on the BioFinder or something.
Right, that's why, and so I think, I mean, like Hannah was saying, this is intended for the regulatory processes where it's not an individual person just looking up what might be on their property. It's actually a species that could be impacted by a project under Act 250 and that produces materials that become public.
Should I move on?
Yeah.
Last section, substantive section, page 15, line 18. This is striking the statutory section that requires the department to reimburse farmers who suffer damage by deer or black bear to their crops.
In the past 3 years, we've had over $207,000 in claims for crop damage, and it's simply just not something that the department can afford. The way that it's written currently is there's no limit on the number of claims from a damage. We cannot afford to pay.
Representative Tagliavia.
Can we make a way so that the DEC budget is hit by this and not your budget?
I think that would be really out of the purview of DEC. It would, I think, be closer to an ag deal.
Is that
Do that?
is that a pretty steady number, or are we seeing an increase, or crops worth more now? So they're
That was a total of 4 incidents over the 3 years that cost that.
oh, that's 207 over 3 years.
Over 7,000 over 3 years. And I don't have the data on what we got in the last year because that number was requested, I think, last spring.
We could take a look at the pattern of requests that come in to provide me specific.
That's what I was just gonna ask, wasn't it one farmer?
There was one very large request which resulted in language that limited the amount per request to $5,000. But the language doesn't limit the number of requests, so it still subjects the department to sort of a potentially a very substantial amount of money be paying out
Obviously.
for crop damage.
Raise fees?
But to our council's question, how many people do those 4 incidents represent? How many different farms?
I don't have that information.
We could ask, yeah.
Representative Pritchard.
How many folks, so you only, how many folks usually request for damage? Yearly?
I don't have that in front of me. Do you know?
And not specifically related to bears, we get many requests, but there are specific requirements that have to be met. The hives have to be registered, the land isn't allowed to be posted. So there's a number of factors that will oftentimes exclude those requests for compensation prior to us paying out. But I don't know the specific number, but we have a lot of bear damage. And
Yeah.
a lot of people have.
And I can only see that growing because you're having less farms, so there's less crops, they're gonna be more centralized, and the damage is gonna be even more for less folks. So,
Yeah.
I'm sorry, what were those requirements for the bear requests?
So there's, excuse me, there's specific requirements around the fact that the land can't be posted. The hives have to be registered, I believe, with the Department of Ag. And there's a few others that I could read if you want to, but basically the idea was to limit someone who just goes and sticks a hive out in the backyard, lets the bears tear it apart and then says, hey, you owe me $7,000 for this stuff.
Yeah.
And so there has to be, you have to make a certain percentage of your income from farming. So it can't be just every hobby farm like I have. You have to actually make compensation from it as well.
Yeah. Right. All right. Thank you, Michael. Would the department like to speak further to what's in the bill? I'm not sure we touched on all of the very beginning sections. Feedback wise.
Yeah, we didn't talk about the fishing tournaments or the free mentored fishing weekend. And I can speak to that.
Michael?
Can I go tell the House clerk that amendment's coming and that you want it on the calendar?
Yeah, we told him, but you could go and write our amendment.
Okay.
Great, thank you. Okay. Right.
Here's shortly. Sure. So the first section, adding the free mentored fishing weekend is a way to, well, it comes at a time of year when almost all of our fishing licenses have been sold. We generally don't sell many licenses after that part of the year. And creating a free mentored fishing weekend is a way to really foster and recruit new anglers. It's a weekend where people are outside with friends and family. We know that having a mentor, it lowers the bar for people to get into a new activity. And so facilitating a new weekend or an opportunity where they don't have to pay for a license but have a mentor to go with them is just increases activity and opportunity. And then to talk about the fishing tournaments, specifically the tiered fees that we're asking for would really just be to show more equity among the various events. Currently, all of the events are charged one fee, $50, and it's been found to be unfair to the smaller events when compared to the larger events that are capable of raising money and utilizing many more resources for the state. So we wanted to have basically a tiered fee system just for equity. And I think for me, I think we spoke on everything else unless. Oh, yeah.
Oh, specifically.
The why.
For reaching the penalty. Oh, and I apologize, I did not, my name's Justin Stedman, I'm the Director of Warden Service for the record. I apologize. The increase for big game violations is that one of the things that we find is that typically many of the violators of those sections are repeat offenders, and there is simply not a large enough deterrent effect to prohibit the behavior. And that's one of the main reasons for increasing. It's also not that it's as big of a deal, but many states have a much, much higher fine for big game offenses. I mean, some of the western states, it's into the, $20,000 range for certain species. So Vermont is significantly, I don't say undervaluing, because I don't, as the law is written in our opinion, the big game is undervalued for its value. That's redundant, sorry.
And with that said, though, your increases are pretty modest, given what you've just told us.
And quite frankly, it's also a matter of working within the criminal courts, because these go to criminal court. And so we have to balance the request for these increased fines with what we perceive as our ability to get them through the criminal courts, because a lot of our stuff, as was said by Mr. Grady, is they're in the same courts where drug dealers and murderers and everybody else is being arraigned and dealt with. So sometimes it's a struggle for the court to address the Fish and Wildlife violations as maybe effectively as they might deserve, at least in my opinion. I'm a little jaded though.
Members have questions? Representative Pritchard, then Nora.
Do you think those are sufficient?
I think it's a step in the right direction, sir. I think, again, we're trying to balance two things, and we recognize that. And I think I think we made a good effort at achieving that balance. So.
Representative North.
I didn't quite understand your responses. Why would having lower fees improve your chances of quicker response in criminal court? I think it would be the other way around. If you had $100,000 fine showing up, the judge might be licking his chops and, let's get that one going through.
I think a lot of, in my opinion, a lot of people, a lot of judges who sit on the bench don't necessarily see the value of Fish and Wildlife cases taking up time in their docket. The fine and everything else came up. And so a lot of times it's simply a capacity issue. And obviously that is true. We've all heard about that. And so the fear was, if we made it $100,000, it would be laughed out of court without any sort of credence given to it, as much as that might, I don't know about 100,000, but to your point, a significant, large increase would be laughed right out of court. We do now frequently get convictions where the judges don't even assign the minimum amount, which I'm not a judge, so it's just, again, it's trying to strike that balance.
Representative Pritchard.
So I know some states, besides the fine aspect of it, at Pennsylvania, you get caught violating a law, the game goes, your rifle goes, what you're driving goes. Is that in place here?
So there is still restitution in place for the animals. So the animals are assigned a value for each species is assigned a value. And so the restitution also exists. This is specific to the fines though. And then in certain circumstances, when we were talking about forfeiture earlier, then the implements of the crime can be forfeited. And that includes vehicles, automobiles. In one case, we had a very zealous warden who tried to forfeit a house because they used the floodlights. So.
Representative Sakowitz.
Earlier, you mentioned that in certain cases that go to criminal court, that certain criminal cases that don't get to court because the person who was fined and they just paid the fine, but they got to. Is this one of those cases, or is that so different?
So this, if I may, this is a complex issue, and I'll do my very best to explain it. So big game violations require us to give you a citation, which is basically an invitation to court, criminal court, where fines are set by the judges supposed to be within these ranges. There are approximately, all of your big game offenses are covered by this. All of your other fish and wildlife violations, so much of your hunting, almost all of your trapping, your fishing, all of that are just violations. And they're not civil violations, but they're called fish and wildlife violations. And for that, there is a waiver fine set by a panel of criminal judges. So for example, if you take a fish that is out of season, I think right now the fine for that is $264. That's decided by the court. we literally write out what's called a criminal ticket. It has the address for the court and it says you have until April 1st to pay this ticket or you must show up in court. And so you as the recipient have the ability of and there's all this information on the back, but people don't read it. And so they have the ability to just write a check and send it in and don't realize that they now have a criminal conviction. Admittedly, it shows up as a Fish and Wildlife conviction, but it is still a criminal conviction. And so these are big game citation, have nothing to do with the other side of what we're talking about of the civil track. Hopefully I explained that.
No, that was clear.
complicated,
That was quite clear. Thank you.
Thank you.
Further questions for now?
If I may, Madam Chair, the only other thing, there was a question about the tournaments
Mhm.
and the fee. We're actually reducing the fees. I just want to make that clear. It's $50 right now for all tournaments. And the idea was to make it less for smaller ones and a little bit more, because some of them, like the FLW and Bassmaster, are 250 boats with 2 people per boat that come from all around the country. So some of these things are massive. And so there was an idea to increase the fees for that sort of
Yeah,
stuff.
thank you.
And with a participant number that high, what would that represent?
$100.
Yeah.
That's what the permit costs.
That seems like kind of giving
Again,
it here.
We're not trying to make money. I mean, they're bringing all kinds of money to the economy. I think what we're trying to do, and I don't mean to speak for you, ma'am, is to cover the time that it takes folks to process the paperwork, really.
Probably doesn't do that.
Probably not, but it's a step in the right direction and helps this change would also help the smaller tournaments.
The tournaments make money though. They charge significantly.
Like LCI you're talking about, something like that.
Similar, yeah, LCI, FLW, which is one of your Bassmasters, all those that you can watch on TV.
Would it be helpful to add a third higher permit fee? Because I'm not crazy about adding fees.
I don't know how we landed on these. I wasn't part of that.
Do you know how many tournaments a year have more than 50 participants?
Very few are bigger than 50. It's those 3. It's the FLW, the LCI, and the Bassmasters are the 3 that I can think of. So
At this point, it wouldn't be that much of a big deal. Okay.
most of your tournaments are the 50 to 30 range participants. A lot of them are that.
Thank you.
All right. Thank you for bringing this.
Yeah, thanks for your time. We'll get back to you with the damage questions.
Members,
Thank
we've finished our amendment work. So we will be on for 9 o'clock tomorrow morning to learn about the bottle bill. We're adjourned for the day.